Hello everyone, welcome to Amigos IAS. I am Adnan. Delhi Chief Minister Arvind Kejriwal has been granted interim bail by the Supreme Court today. The Supreme Court has given 21 days for Arvind Kejriwal in a special request because elections are going on in India and as the Chief Minister of a political party, of course, he is representing Aam Aadmi Party here. He has to campaign in the elections. Elections come once in 5 years. So considering this aspect, Supreme Court has given interim bail to Arvind Kejriwal and asked him to surrender by June 2nd. So let us try to understand first what was the arguments which were mentioned in this particular case. Without, of course, going much detail into the excise policy scam, what was there, we try to understand the court's rationale in granting this bail, and then we will understand also what basically is bail and how many types of bails are there. So let's jump into this video right away. First things first, that is the bail is interim bail, temporary bail till 1st June 2024. So let's try to understand and what actually happened in this particular case. Supreme Court gave interim bail, of course, and June 2 is the date on which Kejriwal has to surrender. Okay, he was arrested when? 21st March 2024 by ED, the Enforcement Directorate, in the infamous Delhi liquor policy case. As soon as this arrest happened, Kejriwal filed a plea challenging his arrest under Section 19 of the PMLA Act, Prevention of Money Laundering Act 2002, gives powers for the Enforcement Directorate to seize and arrest, seize the property or arrest any particular accused if they have some material evidence against the person. That is what is mentioned in Section 19 of the Act. But Kejriwal's lawyer, advocate Abhishek Manu Singhvi has said that his arrest has not fit the criteria as mentioned under Section 19, but means a material evidence, because a lot of witnesses are giving inconsistent statement and his advocate says there is no fit case against Arvind Kejriwal. As of now, as you all know, he is still accused in the case and conviction has not happened. Okay, and the advocate also questioned the timing of the arrest. The court also was considering this aspect here, guys. What is the timing of the arrest? That means as soon as the Model Code of Conduct was announced by the Election Commission of India, within 5 days of that, within 5 days of MCC, the Enforcement Directorate arrested the Delhi Chief Minister. And last week, Supreme Court has suggested that because of elections, they want to give the interim bail. Okay, so what happened? Other events here, guys. So representing the government here, always with government, this Tushar Mehta is there, the Solicitor General and additional SG. Raju, what they have told, Kejriwal was arrested only after the case has developed and new facts have emerged. And they also argued that if you give bail as of now, it will set a very bad example, saying that in the past when the Enforcement Directorate, in the last 6 months, they gave 9 summons for Arvind Kejriwal, but he did not pay any heed to those summons. So as a result, they were compelled to arrest the Delhi Chief Minister here. And the bench observed, the court has told that Kejriwal will not be able to perform his duties, official duties as Chief Minister if he was granted interim bail. That means court was considering the aspect that why can't we grant interim bail? So we will understand, of course, what is interim bail here. If interim bail is given, can the Chief Minister take official decisions and all that? So court has told no. Okay, fine. After today's decision by the court, the government has said that they have dissatisfaction and they told Kejriwal is not cooperating to summon orders. If you release him now, then it's very difficult for us to get him back. Court has told, hold on. 21 days here and there will not make a much difference. Anyhow, he has to come and report on June 2nd. That is what is the court argument here, guys. So let's try to understand basically what this bail is. Okay, bail is nothing but a release of a person from legal custody. Generally, somebody is arrested. Okay, they are in the legal custody. And if you want to not be in the custody, you can apply for this bail. Generally, bail is considered as a norm. Okay, and rejection of bail is considered as exception because we understand Article 21 is there, which gives right to life and liberty. What if some person is unfairly deprived of their liberty? Okay, so they should be given a chance to apply for bail. Okay, you should not wrongfully confine people. That is the meaning here, guys. Okay, the bail is granted as norm while rejection is exception here. And let us see what are the types of bails basically. First one is what? Bailable offense, and then we have non-bailable offense. So as the name suggests, bailable offences are those where you can get the bail, guys. Section 2 subclause A of the CRPC 1973 defines bailable offences. But very important point, bail word is not defined in the Criminal Procedure Code. Offences are defined here. Okay, what are bailable offences here? There are some offences like, for example, causing damage to somebody's reputation, defamation, causing small hurt, small cases. Okay, not so serious cases. They can be given bail as per section 436 of the CRPC. Okay, if you satisfy some conditions. In this case of bailable offences, who can give bail? Either a court or the police may grant the bail. Okay, at the moment of arrest or detention also. That means both court and the police can grant bail. Fine, for the bailable offences. For non-bailable offences, rapes, murders, etc., serious crimes. Okay, so don't be misunderstand the word non-bailable offences. Why, I'll tell you here. Bail cannot be granted as a matter of right unless ordered by a competent court, which means what? Even in non-bailable offences, it is the discretion of the judge which governs whether the bail should be given for non-bailable offences or not. That is the meaning here, guys. So what are the sections here? 437 and 439 of the CRPC 1973. 437 means you can make your application before any magisterial court, before any magistrate, and if you apply for bail in any sessions court, okay, criminal cases of course, and then, or you can also apply the bail in the high court. So just remember these sections of the CRPC, don't get confused. Fine. Serious offences are called as non-bailable offences. Penalty usually is 3 years or more in non-bailable offences. So now we understood bailable and non-bailable offences. Let's now go to the types of classification of bails. Okay, depending on the stage of proceedings, because once you're arrested and what stage the proceeding is, you are accused, investigation is going on, charge sheet has been filed or not. Charge sheet talks about all the charges which can be imposed on a person, and once charge sheet is filed, then the case will start in the court. So at which stage, what bail you can apply, let's try to understand in simple terms. Regular bail, that means as soon as Article 22 says, right? Article 22 says what? That you should be informed about your grounds of arrest and also be allowed to be defended by a legal practitioner. And within 24 hours, Article Clause 2 says that you have to be taken to a nearest magistrate and they will decide whether your detention is valid or not. So what happens suddenly if you are arrested? You can apply for a regular bail application. Okay, if you are detained by the police. So what happens here? The accused has the right to be freed if the courts, for example, I don't know, section 437 magisterial court, 439 means you can approach the sessions court or high court. Any place you can apply the bail application for regular bail, but it takes some time. So regular bail means what? Simply releasing an accused from jail to ensure their attendance at the trial. That means bail is a guarantee you give that I will come back whenever you ask in the trial stage is going on. That is temporary release here, guys. What is interim bail? Okay, interim bail, as we have seen just now. I'll do one thing. I'll come back to interim bail just in a while. Let me go to the third one, which is anticipatory bail. Anticipatory bail is also, is mentioned in this sections 438 of the CRPC. Okay, so what happens here? Anticipatory means you are expecting that you can be arrested, usually for some non-bailable offences. Bailable, why you will be worried, guys? For non-bailable offences, if you feel somebody is going to crack down on you, for example, in recent years, corporate competitors and other prominent persons sometimes want to target some of their competitors by fake charges. So you know that you're going to be arrested for some important case. And then what you have to do is, before you're arrested, what you're doing is, in anticipation of your arrest, you're filing this anticipatory bail as per section 438. If the court grants you the bail, okay, 438 CRPC talks about this anticipatory bail before the arrest. Okay, so what happens in this case of the court? You have to convince the court that you are not guilty of certain things, okay, and you can tell your condition that you are not having, good health or some other serious condition is there. If you're able to convince the judge, then he or she may grant you anticipatory bail as per section 438 of the CRPC, that is anticipatory bail. What is statutory bail? It is also called as default bail. Default bail means what? Like there is some time limit. You cannot be confined in the custody for an indefinite period of time. So once FIR is filed, a case is booked. Okay, in anticipatory bail also FIR usually is filed. Otherwise, how will you go and file a case? How will you file a request for anticipatory bail? So once the first information report FIR is filed, so what happens is generally the police or the investigating authorities have to file the charges against a person. Charge sheet it is called. So for offences, okay, for example, for an offence which is having less than 10 years of imprisonment. For an offence, if there is less than 10 years of imprisonment, then within 60 days, the police or the authorities have to file the charge sheet. After that, the case will go on. If it is more than 10 years or lifetime imprisonment, then what happens? Around 90 days time is given to file the charge sheet. If you don't file the charge sheet in these cases, then it becomes your statutory bail. That means default bail is guaranteed in these cases. Fine. So under the normal sections of 437, 438 anticipatory bail, and 437, 439 regular bail is there. So under these sections, what happens is in this generally what happens, you see here the remedy of statutory bail. Okay, wait, hold on. Small corrigendum here. Statutory bail, also known as default bail, is different from the bail in the ordinary procedure under CRPC. Just small correction here. Ordinary bails, like we have just now seen, the regular bail 437 and 439, that means before magisterial court or before the sessions court or high court, you can file these cases, regular bails. Anticipatory bail 438 we have seen. Statutory bail is defined in 167 clause 2 of the CRPC. So please make sure you note this point. 167 clause 2 of the CRPC. It is there. I hope the writing is visible on the screen, guys. So 167 clause 2 is the default bail. Why it is news? Because last time what happened is in Ritu Chhabria case, Supreme Court has told that, okay, if the investigating authorities are not able to file charge sheet within 60 or 90 days, depending on the law, then default bail becomes a fundamental right. So sometimes in some genuine conditions, the authorities may not be able to complete the investigation. They can inform the grounds for the court also. So if we say it is fundamental right, what happens? Then automatically, as soon as this time limit is over, you can be getting the bail by default. So this has some ramifications. Ritu Chhabria, okay, Ritu Chhabria, check the spelling later, guys. Ritu Chhabria versus Union of India case, court has told that statutory bail, default bail is fundamental right. But then the government, the advocates have filed, the SG has asked the Supreme Court to reconsider this verdict. Supreme Court put a hold on this particular verdict, which means today it still remains a statutory right. Statutory bail it becomes, guys. Okay, as per 167 of clause 2, not a fundamental right because court has put the case on hold. That means any other court, for example, district court, sessions courts are there, high courts are there. If somebody comes with the application, that means what, guys? 60-90 days, if you don't complete the charge sheet, by default, you won't get the bail usually. You have to apply for an application, you have to apply. Application once you give to the court, then the courts can consider your request for statutory bail, no bar on that. Just that what Supreme Court told in Ritu Chhabria case that it is a fundamental right, that has been put on hold. Okay, so hope there is no confusion here. If you still have confusion, please post in the comment box. I will be happy to clarify. Anticipatory bail before somebody's arrest. Okay, 438. And then we have this interim bail of Kejriwal. What happened in this case? Interim bail basically does not have any provisions in the CRPC. Generally, when you apply for a regular bail or anticipatory bail, regular or anticipatory bail if you apply, so what happens is sometimes opportunity should be given for a person that, let's say you applied for an anticipatory bail. The court will ask you the reasons why you want to apply for anticipatory bail, and you need to have some time for that. But in the meanwhile, if you put you in jail, it is not good. So I will say, okay, fine. For some temporary period, I am going to give you interim bail. Meanwhile, let me hear your final anticipatory bail or regular bail. For that, I need some information. So what they will do is, okay, let me grant you some time. After that, you come back and then let us consider your application for the regular or anticipatory bail. I repeat, for regular or anticipatory bail when you apply, sometimes it may take some time for the courts to take a decision on that. So what happens in that case? because your life should not be deprived, your liberty cannot be deprived, they will say for some temporary period we are going to give you some relief. That is the meaning of interim bail here. So in this case also the court has given what? Interim bail only, because regular bail application is pending with the courts. Fine. Meanwhile, if the court finds you not guilty, then you are free, of course. Fine. So interim bail is for a short period. It is given to an accused before the hearing or for regular or anticipatory bail. In Sukhwant Singh versus State of Punjab, Supreme Court held interim bail is a measure to safeguard reputation of an accused. Okay, so understand these points. Last point before I end the session, how to apply for bail. Of course, you need to sign a bail bond. It's a legal instrument where you have to give some surety, guys, and pay some amount of money also, and there should be at least 2 sureties who will give guarantee that you will come back, okay, whenever the case at the police station or when the trial is going on. You have to be present for the court proceedings also. That is a surety you have to give, guys. So bail bond means what? It's an agreement by the accused to appear in court and cooperate with the investigation, and you have to pay some fee also. Other limitations, the person should not leave the country without taking the permission of the court while you are on bail, okay, or the bail bond. Okay, that is also there in the bail bond. If individual fails to follow this bail bond because you have yourself signed and gave, then what happens? A warrant for their arrest will be issued. So these are the bail provisions in the CRPC. Again, for the UPSC exam perspective, that much depth is not required usually, but try to understand the different dimensions. If they are repeated more in the current affairs segment, guys, then you will be able to, you can be tracking some news and make some notes for the mains answers. So I hope you understood the topic. If you have any more questions, please post in the comments box. I will be happy to clarify your doubts. So I'll see you next week with some other video. Keep watching Amigos IAS. Thank you.